Okay, so these slides talk about ethics in the general sense and then get into ethics in relation to library and information studies. So, what is ethics? When I think about ethics, basically I think of the phrase do the right thing. I think that it works as a guideline, but the real question often is what is the right thing? Ethics have a lot of grayness. Sometimes it's hard to know what really is the right thing to do. And it's especially hard if you can see multiple sides of a situation. And in formal ethical thought, there are multiple ways to make ethical decisions. So these are some of the foundations about ethics. Ethics is a branch of philosophy that examines and studies concepts about what's right and what's wrong. Ethics is related to morals, moral systems, and human conduct, about what we should do and should not do, what's good or not so good. Ethics is also about our rights as people and our responsibilities as people, as well as to other people. Ethics also includes systems of rules, principles, values about behavior, and this can be in terms of culture, religion, or various professions. So, what about ethics and the law? How do you see these in relation to each other? So, the law is not necessarily about what's good or bad. The law does not tell us what's moral. The law's purpose is to satisfy a society's requirements. It offers rules that are about authority, but not necessarily about morality. Now, they can be about morality, but the purpose of the law is to manage a society in such a way that there are prescribed rules on how to act. So, for example, we all might agree that stealing is both illegal and immoral, but we also might get into ethical questions about what if someone is desperately hungry. According to the law, stealing is illegal, but are there situations where we might view stealing in a different way? And what about slavery? It was once legal, but I think we would all agree that it wasn't moral. And also, it was illegal in Nazi Germany to harbor Jews. But where is the morality in that? But we do, of course, have some laws that clearly relate to ethics. We have the First Amendment, which relates to access to information and free speech. And we have the Fourth Amendment, which relates to privacy. And both of these have had laws enacted based on them. So there are definitely overlaps between legality and morality. So let's take a closer look at the First Amendment, which says Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. So, what is this about? Courts have interpreted the First Amendment to mean that we have a legal right to free expression and that we have a legal right to information and to exchange ideas. So basically, the First Amendment is about intellectual freedom. And this is a core ethical value within the library and information profession, which of course you all know. It's not our job to make judgments about what information is appropriate or inappropriate for a given audience. So, what about children? Access to information includes providing an environment of safety and intellectual freedom for children as well, both in the classroom and in the digital environment. But this is actually a very gray area. We don't necessarily provide equal access to children, and this often depends on individual libraries and communities. So, for example, back in 2003, an Arkansas school district in Cedarville, Arkansas, voted to restrict students' access to the Harry Potter books on the grounds that they promoted disobedience and disrespect for authority and dealt with witchcraft and the occult. So after that happened, students in the school district had to get a signed permission slip from their parents before they would be allowed to borrow any of those books from the school library. But this was brought to the court system, and the district court overturned the board's decision and ordered the books returned to unrestricted use on the grounds that the restrictions violated students' First Amendment right to read and receive information. The court ruled that the Board of Education was still bound by the Bill of Rights and could not abridge students' First Amendment right to read a book on the basis of fear because they disagreed with the ideas in the book. More recently, and I can't remember which year it was, in Arizona, a friend of mine told me that they were actually firing school librarians because the librarians were defending the right to have certain books. So there's something called the Children's Internet Protection Act, which says that libraries that receive certain federal funds are required to install internet filters on their computers. The problem with this is that filters also block a lot of important and protected information. So libraries can remove filters for adults if they ask, but this then becomes an issue of privacy for adults. So, for example, filters might prohibit someone from looking up breast cancer because it has the word breast in it. So then that means that whoever is looking it up has to ask a librarian to lift the filter, and of course, then that does become an issue of privacy. Now, if public libraries don't get federal funding, they don't have to deny access to inappropriate sites. But in school libraries, the Supreme Court has said that minors don't have a right to receive information if the information is educationally unsuitable. But again, how do we decide what is suitable or unsuitable? Who decides that? So let's look at the Fourth Amendment, which says the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause. So, what is this about? The Fourth Amendment basically gives us the right to be left alone. And in libraries, this means protecting the privacy of circulation records, which usually means destroying them. In the digital age, this is even more complex because so much is not private anymore. We can be traced online and our information is compromised. So in the library, this can mean that there are privacy-enhancing technologies. So what about the USA Patriot Act? What is it and what does it mean? So USA Patriot Act stands for Uniting and Strengthening America by providing appropriate tools required to intercept and obstruct terrorism. So if you didn't already know, the capital letter of each word spells out USA Patriot. So basically, after 9/11, President Bush signed the Patriot Act, which expanded the authority of the government to gain access to all kinds of records, including businesses, medical, education, and library records, including stored electronic data. It also expanded laws about wiretaps. And in terms of libraries specifically, this includes circulation records, book purchase records, membership lists, subscription lists, and website visitors. What this also means for libraries is having up-to-date privacy policies that include collection, retention of data, privacy of reference questions, etc. Because if there's a subpoena or warrant, the library does have to give up the information. But if it doesn't have the information, obviously it has nothing to give up. So some additional facts about the Patriot Act. In May 2011, President Obama signed the Patriot Sunsets Extension Act, which was a 4-year extension of 3 key provisions in the Patriot Act: roving wiretaps, searches of business records, and conducting surveillance of lone wolves, which are individuals suspected of terrorist-related activities but not linked to terrorist groups. On June 1st, 2015, parts of the Patriot Act expired, but then on June 2nd, 2015, the USA Freedom Act was signed, and the expired parts were restored and renewed through 2019. However, the law was amended to stop the NSA from continuing its mass phone data collection program, but instead, phone companies retain the data, and the NSA can obtain information about targeted individuals with permission from a federal court. And the Act still contains the ability of the government to continue with wiretaps and surveillance of lone wolves. So let's talk about intellectual property. This encompasses inventions, literary and artistic works, symbols, names, images, and designs. And there are 3 systems of intellectual property, and these are trademarks, patents, and copyrights. I'm only going to talk about copyright because this is the area of intellectual property that is most relevant to libraries. And I'm going to give you a quick timeline of copyright law in this country. So copyright law began in 1790 with the idea of protecting creative works so that creators would gain reward from them. But copyright was limited to only 14 years so that there was also a commitment to the common good, meaning that the idea of a public domain was critical to the common good. But over the years, there were a number of changes, and this is kind of a quick and dirty list of the changes, and they're a lot more complex than just listing the dates. But in 1831, the terms were extended to 28 years with a 14-year renewal. In 1909, the term was extended to 28 years with a 28-year renewal. And one of the big changes was the Copyright Act of 1976, which extended the term to either 75 years for existing works, for existing copyrighted works, or the life of the author plus 50 years for things copyrighted after January 1st, 1978. It also extended copyright to unpublished works. So all of your papers are automatically copyrighted by you. In 1998, there was the Sonny Bono Copyright Term Extension Act, and this extended the terms to the life of the author plus 70 years, or for works with corporate ownership to 120 years after the creation, or 95 years after publication, whichever endpoint is earlier. And yes, I know this is confusing. It's confusing for me. The act was also called the Mickey Mouse Protection Act because the copyright on Mickey Mouse was about to expire. Also in 1998, there was the Digital Millennium Copyright Act, which was to protect copyright on digital material and to reduce piracy. Under this law, academic institutions fell under what is called the Safe Harbor Law, which meant that they were originally not held responsible for what students did, but now they are expected to have policies that restrict things like file sharing and other digital copying. And with copyright comes the idea of fair use, which permits using copyrighted materials without permission based on these four factors: the purpose and character of the use, which means whether it's commercial or educational, the nature of the copyrighted work, meaning whether it's factual or creative, the amount and substantiality of the portion used in relation to the whole, and the effect of the use upon the potential market for the copyrighted use. So, for the most part, if the use is educational, if the work is factual rather than creative, if a small portion of the work is being used, and if the use of it does not affect the market value of the work, then it's fair use. So, one more thing I just want to say is that there are always going to be questions about what's the right thing to do. Nothing's black and white. You may be balancing your beliefs against your organization's beliefs. You might have conflicting loyalties. You may end up having to balance a library's survival against your personal ethical standards. You might also think that people shouldn't have access to certain kinds of information, but as a librarian, it's your job to make sure they do have access to it. And that is it for today.